We will start short.
The Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated. If I can get you to move that little yellow piece of paper. Good morning, all. This is the morning session on October 20th, 2021 of the 10th Court of Appeals. At this time, there's one case on the docket for this morning session. I would ask for the announcements from the counsel that's going to make the argument. We don't allocate argument time. We don't track it other than total time per side. You should have received notice that that's 20 minutes and 20 minutes, 5 minutes rebuttal for the appellant. And that's what will come up on the timer when you're at the lectern. Please check your cell phones, or if anybody has a antique pager, make sure that they're turned off or silent. I need to do that with my own. This proceeding is being live streamed on the court's YouTube channel. We had started recording oral argument before the pandemic, but with the advent of the pandemic restrictions on access to court proceedings, they set up the YouTube channel for the public access. And we now just link that video that is recorded to the cases in our TAMES case management system now. So in the future, if you need to refer back to the oral arguments, they are both video and as well as obviously the audio are recorded and are in our TAMES system. We do allow folks to move about the courtroom. Since we only have one argument today, this morning, it shouldn't be much of an issue, but if you do move, be respectful of the person at the lectern and try not to distract the court in its proceedings. To my left, we are honored today to have the retired Chief Justice of the Eastland Court of Appeals, Jim Wright, to sit with us as a member of this panel. Jim brings it's not an understatement to say decades of judicial experience to the bench. He was a longtime district judge in Eastland before he became a justice on the Court of Appeals, and then later became Chief Justice of the Eastland Court of Appeals, and he is now retired. So I take a lot of, would it be guff and from my colleague, we've known each other for years. To my right is Matt Johnson. Most of y'all will know him as being a trial judge for more than a decade here in McLennan County from the 54th District Court here in, like I say, in McLennan County, was elected and has been with us on the Court of Appeals now for years. So he brings a wealth of judicial experience as well to this bench, and we're
Giving me 2 extra months. It's 10 months so far.
Oh, yeah, okay. Well,
But I'll take them. I'll take them.
10 months, 10 decades. Oh, well, not quite 10 decades, but getting close, getting close. So with that, I'm going to call the docket. If there are any exhibits or any other preliminary matters, now would be when we do the announcement, would be the time to bring it up. I guess technically there are 2 cases on the docket today. It is cause number 1020-00133 and 1020-00145 CV, which is the appeal and the mandamus in Scott versus S2S domain and Aspen Heights Waco project. Could I have the announcements of who's going to argue?
Your Honor, Andrew Mason, Jim Dunn, and Dave Demas here for the plaintiff. I will be handling the primary argument rebuttal, and Mr. Dunn will be arguing for a couple of minutes, just to the extent the court may have any questions at the end of the open argument.
Okay, and bear in mind, I don't allocate time, don't keep up. If she uses up all your time, it's just used up. So
Yes,
understand that. Okay.
Ian Bellavoe for Aspen Heights Waco Project Limited.
You have a docket sheet. I've left mine in my office. Or does any of the staff have a docket sheet for this case?
Lift mine and all.
Yeah, I just want to make sure that all the attorneys are on the, that's all right. We need to make sure that we have you on the record so that you get notices. Same with you, Ian, and you were about to introduce yourself.
Sorry, Your Honor, I was just waiting for the.
No, you go right ahead.
Okay. Thank you, Your Honor. Israel Schuster on behalf of the other appellee in this case, which is S2S Domain Waco Associates LLC, referred to as Domain.
Okay. Metha,
Meta,
Meta.
MEHTA.
Okay. Yeah, we were handed one. Thank you. Ian, could you pronounce your last name for me again? Very
Yep.
slowly.
Bellavoe, Your Honor.
Bellavoe. Okay, thank you. That's not a spelling or pronunciation that I had seen before. So with that, Andrea, you may proceed.
Thank you, Your Honor. You remember my master argument?
You do not. In fact, anyone that wants to take their mask off is fine. It is a personal preference. That is up to y'all. When I move around, I will normally wear mine, but that is a personal choice in here.
Thank you, Your Honor. May it please the court. My name is Andrea Mata, and I, along with my co-counsel, represent Terry and Kim Scott, who are the appellants and the plaintiffs below. This case is pretty troubling because the trial court has made significant procedural and substantive errors that mandate reversal. With respect to even performing the ministerial duty of finding a date when actual knowledge is acquired for purposes of Rule 306A of the Texas Rules of Civil Procedure, the court simply did not make that finding. Now, it's clear it's an abuse of discretion, but because the remedy is murkier and has been, various courts have applied different remedies, we've presented multiple options to the court. Substantively, the trial court also erred in its grant of summary judgment because we outlined all the reasons in our brief, but for today's purposes, I'm going to be focusing on the trial court granted summary judgment, despite the fact that Aspen and Domain did not address all of the causes of action in plaintiff's pleading. In brief, they only talked about construction. The Texas Water Code prohibits someone impounding water and diverting water, but it also prohibits them from maintaining or permitting that condition to continue. So allowing that condition to continue or maintaining is also against the statute. Additionally, the trial court summary judgment granted, the trial court granted summary judgment solely on limitations. We have a specific order from the court here where the order made clear the grounds. And despite the fact that we have in our life pleading a request for an injunction, the court granted summary judgment, and that's error. With respect to Rule 306A and going into the different options we've provided to the court, the abuse of discretion is clear. Across the line, if the trial court fails to make this finding, it's an abuse of discretion. As we pointed out in our brief and our mandamus, the remedy is a bit murkier. There are some courts that have proceeded via direct appeal. They have abated the appeal and they have sent the case down to the court, to trial court to make the finding and then proceed with the appeal. However, troublingly, there are other courts that have said, if you do not have this finding when you appeal, there's no jurisdiction to appeal. And so they've dismissed appeals on that basis. And those courts we have cited in our brief. And while they're the third option, So with that, in that regard, to address that, that's why the mandamus was filed. So this court has the option to, through the mandamus, direct the Court of Appeals to make the finding. Now, the third option is to proceed via direct appeal and to find that the trial court made an implied finding. That has been the Supreme Court, there is case law where the Supreme Court has done that. However, the same cases that dismissed the appeal by saying there's no finding have distinguished that Supreme Court case by saying it only is when you have a grant of a motion for new trial that they allow that implied finding. We believe that the court is fully authorized to act and supported by the law in each of these three avenues. With respect to the direct, if this court finds that there is an implied finding, we have briefed and we believe that the evidence is clear that the trial court abused its discretion because under the record, the only conclusion the court has shown is that they're allowing constructive notice. Now, as this court is aware, Rule 306A, it governs the procedure for when you have a final order. Rule 306A.3 provides a mandatory duty for the district clerk when there is a final order filed, district clerk mails out this notice of appealable order. And they're told to do that promptly. Rule 306A also says that this does not affect the time periods if the clerk doesn't do it unless the conditions of 306A.4 are met. This case is a 306A.4 case. And what that means is in the rule, they've contemplated what happens if the district clerk does not perform this ministerial duty for whatever reason. And what happens in that case is if you find out between 20 to 90 days, the court says you file a sworn motion with the trial court and say, this is when I acquired actual knowledge. That is precisely what we did in this case. This case is unique in that we have an order that was never filed. As of the date this appeal was filed, we showed in the record that the order is still not filed as a standalone order. This order granting summary judgment. Instead, it was signed and it was emailed to two of the attorneys from a non-official 414 email. It was emailed from the email address of the court coordinator. When the previous day,
For purposes of the notice to council, I know there's a procedure through which you designate as council what email address to send notices to. Does it matter what the source of the notice is? The source address of the email?
I don't believe that that matters. I was just pointing out why it's procedurally irregular. What matters is the email was not seen on that day and was not seen and was not even discovered until January 30th. So the source is just pointing out that this case has been plagued by multiple irregularities that typically do not happen. Typically, you do not have an order that's never filed, and you're supposed to have appellate timetables running from an unfiled order. In this case, the order is only in the district clerk's file as an exhibit to one of opposing counsel's 306A response motions. And that's the troubling part. Now, the statute allows a remedy for this. It says if the clerk never mailed this notice, which is uncontested here, no notice was ever sent out pursuant to A3 because the order was never filed. So if that happens, the remedy is you have to demonstrate when you acquired actual knowledge. My law firm, every attorney that worked on this case, including myself, we signed sworn affidavits saying that we did not have actual knowledge of this. It's sad to say almost a comedy of errors, even though there's nothing funny about this, where the day before this email was sent out to Mr. Dunham and Mr. Dumas's email address, in addition to opposing counsel, the parties were discussing back and forth the form of the order, the issues of objections, and Mr. Dunham made clear on November 4th that we're going to appeal this case and so we can't sign off as to form. The next day, less than 24 hours later, instead of a reply all to that chain where every single person was copied, a separate email went out from a separate email address, not the 414th email. And that's the one that had the final order in it, but no one saw it. In fact, we did not discover the existence of this order until Mr. Dunham called the court to set a status conference.
Do you have to know the contents of that order? You mentioned about the order still hasn't been filed and all that sort of thing. Do you have to know the contents of that order, or is that a part of your notice, or do you just need to notice that once it's been filed?
No, Your Honor, I don't think you need to know the contents. I think you need to know that there's been an order. And so there are
signed by the trial court.
Right. You need to know there's been an order. In this case, there was no one knew there was an order. Now, the problem with what Domain and Aspen argued in the trial court level and what the trial court found is they said it's enough if the email hits your inbox. The problem with that is the statute requires actual notice. Now, we have cited a case to this court. We've cited multiple cases, but one that's startlingly on point is a United States Supreme Court case that doesn't even address 306A. You wouldn't think there would be one on point, but that case, the Intel case, dealt specifically with what constitutes actual knowledge for purposes of a statute that requires actual knowledge. And that was a case that dealt with limitations. And in that case, the individual received an email it was a breach of fiduciary duty case. And the individual received an email that told him that supposedly these bad investments had been made, but he did not read it. The other side argued he was emailed this. He had notice. And the court said that if an appellant is not aware of a fact, he does not have actual knowledge of that fact, however close at hand that fact may be. And moreover, in a Texas case, in the LDF case, which we cited, in that case, a clerk told the party, the court's made a decision. And that court said, that's still not actual knowledge because you don't know an order's been signed. And that's the key here. Either actual knowledge means actual knowledge or it doesn't. we are wading into dangerous territory when we are rewriting the rules, and that's precisely what the court has done in this case. But because at the end of that February 4th hearing, the court asked counsel for domain and asked them, so you're saying it's enough for a party to just have it in their inbox, and they said yes. And the reason it's not is because that's constructive notice. Now, I anticipate counsel will come up here like they did in the trial court level and say, and have some hyperbolic assertions on why the floodgates are going to open with this, why this is going to be so detrimental. But the problem is, Rule 306 already has this fail safe. We would not be in this situation at all if notice had gone out by first class mail under A3. We would have received it. Even if the trial court filed the order, we would have received it through the e-filing service provider. All attorneys who were on the case would have received it. This only happened because an order was not filed and notice was not sent out. So already there, you are limiting the parameters of the type of case that applies here.
Say notice was not sent out, you mean notice as required by this rule?
Correct.
You're not just saying no notice at all, you just said no notice was filed according to the rule.
Correct. What 306A does, Your Honor, is it differentiates between the type of notice. Under 306A, you have notice from the district clerk. A4 does not use notice. It says actual knowledge as the standard. So if you don't get the 306A3 notice from the clerk, if you don't have that and you don't have actual knowledge, then your deadline shall mandatory.
If the clerk had mailed the letter, first class mail, and it had gotten stuck under some other mail for 6 months, tell me what about that scenario?
Then it would still be in the A4 situation because the person, first of all, the person, as this court held in the Gifford case, when you prove that you have not received this notice, so the person would have to come to court and say, I didn't receive this notice, have a sworn motion, and it's incumbent on the other side to bring evidence saying that here, look, it was mailed. And
I guess what I'm asking is if you look just like the email, you notice that it was there later. Notice that it had been delivered to you. Can you, let me see. Can you say that if I don't notice some first class piece of mail that I've been gotten, that doesn't matter? That's not noticed until I find it?
well, Your Honor, in your first part of the hypothetical, you had mentioned 6 months, that can you do it after 6 months? And you can't. Within 90 days, if you get the letter, obviously that shows notice is under A3, and A4 only applies if notice is not sent under A3 or you don't have actual knowledge. So you would have the A3 situation happening there, which would preclude an argument that they didn't get notice. So this is not a situation where an attorney can.
So you're saying it would be constructive notice if they had gotten a letter from the clerk that the content of the letter was a notice of an entry of judgment. Even if they didn't open that letter, they would have had notice under 306(3)(a).
Well,
But because that notice we know wasn't sent, then you're dealing solely with constructive notice.
correct.
Actual notice.
Correct. And I'm not saying that there may not be a remedy under a bill of review, but 306A4 specifically says that if within 20 days after the judgment, a party adversely affected has neither received the notice under paragraph 3 nor acquired actual knowledge, then that's when A4 comes in.
Well, I think what Jim was trying to ask, correct me if I'm wrong in my paraphrase, if they get the clerk's notice, does it matter if they got actual notice?
No, Your Honor, I don't believe. If you have the clerk's notice mailed out, this says your period starts. And if for some reason, there have been, I'm sure there have been cases where the notice was sent to an incorrect address, or if it wasn't delivered. In that situation, they can argue they never received the notice and never had actual knowledge. But the point is the rule A4 deals with if the notice is not sent and you don't have actual knowledge, your dates are going to begin on the date you have actual knowledge.
Chief has done a good job of paraphrasing my question. I want to take it a step further. 306A4 says that you neither received notice nor have actual knowledge, right?
Correct.
Both of those things are in the rule, correct?
Correct.
Back to my example of there's a notice under 306A3. If the clerk mails that letter to you and you don't see it before 90 days, okay?
Right.
You've got notice, right? Regardless of whether you see it or not.
Right, you've received it at that point.
Right, you've received it, and so you have, under four, you have received the notice required of paragraph
Correct.
3,
So,
okay? And that's with the first class mail and all
Correct.
that stuff. So if they do that by email and it hits your inbox, the same as the paper will hit your desk, why is that not noticed?
I don't think that, Your Honor, respectfully, they're not permitted to do it. The rule says it has to be by first class mail. And so if
What
we,
about Rule 21?
I think that rule with respect to statute, any sort of statutory construction, when you have a general statute and a specific, the specific's going to control. In 21, when you have Rule 21 and you're dealing with regular pleadings and things of that nature, here, this is not a service statute. This is a statute telling you when your appellate periods are going to run.
I think Rule 21 says under subsection F10, I believe it says that the clerk may issue different things, including, it says orders. The word orders is in there. I thought it was strange that it would be a statute or a rule that pertained to motions and pleadings is the heading of it. And when you get down into F10, it says it contains the word orders.
And respectfully, Your Honor, I believe they can send it. Nothing precludes them from sending it. But when you look at this specific statute, 36A doesn't talk about when it's effective or not. It talks about when do your periods begin to run from the signing of judgment. And it makes sense when you think of the rule exists and there has to be some sort of protection for litigants who don't know when a court signs a judgment. So yes, you can have notice via other ways, but this specific statute says when you want to determine for appellate purposes when your appellate timetable runs, it is through the parameters of this statute. And what this statute says is notice by first class mail. Now, the actual knowledge part, I think it's significant because the truth is when you have, here in this case, there's uncontested testimony. This court said in Gifford, if you have a sworn motion and you, pursuant to 306A, you have made a prima facie case, the court looked and said there was nothing on the other side presented, no other evidence. So that showed that the court was correct in finding that the date ran from the date of the sworn motion. Here, we have a sworn motion. Mr. Dunham subjected himself to cross-examination when he did not need to do that because he wanted to be candid with the court about what happened. The opposing counsel, they cross-examined him, but they did not present any evidence. They did not present anything to show that actual knowledge was not received.
Is the trial judge entitled to draw an inference from the date of delivery of Ms. Dunn's email?
No, Your Honor. Under the text of the rule, the judge is not permitted to do that because the standard is actual knowledge. And when it comes down to it, either actual knowledge means actual knowledge or it doesn't. With the trial court's decision, it's rewriting the rules. It's not just fudging, it's rewriting them because as the United States Supreme Court said, if you don't know a fact, you don't have actual knowledge. And so to say that if it hits your inbox, it doesn't matter it doesn't matter if there's an earthquake in your office is destroyed the next day. If it hits your inbox, you have notice. That does not fit within the parameters of the statute.
You're talking about 308.
306A4, yes, Your Honor.
A4.
Yes.
I'm still having trouble nutting. Are you done?
No, I'm here for the duration, but yeah, I'm
I'm still having problems with it says you has neither received the notice nor gotten actual notice. Why does it say? What does it have to do if actual is the only thing that matters?
Well, Your Honor, respectfully, it's talking about when it says receive the notice required by paragraph 3.
Right.
So actual notice method. So you have these two things. If you don't get no notice of judgment, so if you, the district clerk, is what happened in this case, we don't get this notice. Actual knowledge is what matters because the court says
Did you get the notice though? Did you get a notice from somebody?
we did not get what the notice in A3 says is the clerk of the court shall immediately give notice to the parties or attorneys. That's talking about the district clerk.
Okay, that's where I'm trying to go. You're having a problem with who delivered the notice.
Your Honor, not the district clerk. This was a court coordinator.
I understand, but that's your difficulty here is that the coordinator didn't need to do this, the clerk did.
The district
And
clerk
that's
did.
causing the problem.
Yes, and the district clerk in this case, under this subsection, I know that the court has seen this, they mail out what's called a notice of appealable order. And that's a notice that's contemplated here. that the district clerk sends out this notice, and it's by first class mail, and the parties see you have this order signed, it's triggering your appellate periods. Now, 4 says, if that doesn't happen, here's the remedy. And the court, the reason that there's no need to worry about floodgates is the statute, or excuse me, the rule has said specifically, it's only with these parameters. It's only in this time period. And the time period is 20 to 90 days. And that's where the balance was struck in terms of a litigant's right versus affording finality to judgments.
I
And so,
apologize for taking so much time with my questions off.
no apology
You may
necessary,
move
Your
on.
Honor.
I didn't want to take your time either, so
No apology
You got it.
necessary.
go ahead, go
I don't know how much the court wants to hear about the substantive arguments regarding limitations, or if you want to hear from Mr. Dunham to answer any questions regarding the email, I will defer to the court for that because I have presentations on both.
Okay, we're good. And we will, obviously, from the questions as well as your presentation, you know, that we're focused on the jurisdictional issue of the notice. So
Yes,
you
Your
know
Honor.
where we are.
Yes, Your Honor. So I will see the remainder of my time to Mr. Dunham to ask any questions, to answer any questions that the court has. And I look forward to speaking all during rebuttal.
Obviously, it's self-evident this guy is the one that is good for these arguments, and I can assure you 90% of what you're reading, or 95% of what she wrote is very good, large amount of it. But it's a unique circumstance, and I think Mr. Dumas and I owe to stand up in front of you and answer any questions you have. 2 emails came from Ms. Dunn downstairs, the course coordinator, and didn't see them. I don't provide you with any excuse. We did provide an explanation, and how I know we didn't read it, because I look at emails, I get several hundred a day, like I'm sure you do. And if I see that Nicole in my office or Andrea in my office, who I know are going to be involved in these matters, I forward them, bam, bam. And so we sat around, no order. My staff checked with the district clerk as an order on file, but there was no order. So 60, 90 days go by and I didn't know what to do. I didn't want to file a motion to enter judgment because we don't want the judgment, obviously. So I filed a motion for status. Let's just go have a hearing and ask the judge, what's the status of this order? After we filed it, we actually got a hearing date. We get a call from Ms. Dunn saying, oh, I sent you this email back and whatever. Oh, goodness. Went back, look, there's an email in the inbox. And it's from Ms. Dunn's personal account. But to answer your question, Your Honor, the notice, if we'd have gotten even an email from the district clerk, we're out, right? I mean, it's constructive notice. You get something from the district clerk, a notice of appealable order, you're out. We would be here talking about actual words. That did not happen. And thankfully for my client, the law is that if you don't get that notice of appealable order, and this is a very unique circumstance, no order has ever been filed. I don't know whether it got lost. There is no original order anywhere. This circumstance does apply. And the one question I want to answer that I didn't speak in front of Ms. Judge Menard.
And now if it's not in the record, we can't have it.
No, this is,
Okay.
I mean, it's to answer the question that's asked on the rest record that I think was asked. And that is that, well, goodness, how's nobody gonna, everybody can do this, right? No. That disrespects the oath of office, the oath that we have as officers of the court to tell the truth. It also disrespects the fact that you are under oath and that's the safeguard. That's the safeguard.
Counsel, let me ask you one question.
Sure.
Can the trial judge, based on the fact that Ms. Dunn sent an email within the 20 days to your designated email address, can we infer from the record that, knowing that happened, that the trial court made a finding implied that provided you with actual notice?
I don't see how under the record, because there's no, actual notice versus actual knowledge is 2 different things. Knowledge is you actually know about it. Notice is a constructive notice that we're all familiar about, that whether you read it, if you got it in the mail and it's set under your desk and you didn't read it, you're still constructive notice if it came from the district court. No question about it. But under the record we have, I don't see, there's no evidence of anything other than me and Mr. Dumas didn't realize this until Ms. Dunn called us 89 or whatever the number of days out and said, oh, well, this order was signed when we were attempting to set a status conference. That's the only evidence of when we actually had actual knowledge. And, this is a circumstance where, like this deadline, as you know, filing a notice of appeal is about a one-page deal. There's no benefit in delay for my client. We're going to appeal the deal. That's in the record. And we weren't sitting around, we were sitting around waiting for an order to hit the district clerk's office and get our notice of appeal order. We didn't think it was signed.
Thank you, counsel. Any other questions? Any questions?
I don't remember if the record reflected it when I was going over it, but I know that there was something in the record about the emails going back and forth and y'all taking the position you want to appeal and you can't sign off on it. And I certainly understand that. And then it said something about it may have been in a brief, the order or the proposed order was then sent to the trial court for entry and the trial judge entered it. Were you included in on those emails? And if it's not in the record, we can't consider it.
So these emails are in the record. And the one in particular that we were always going to appeal it. And there had been a summary judgment granted as to one party previously, right? And that got filed, but we got to wait on the second one. And so the other defendant filed their motion. And so we're waiting on that. The form was going back and forth. And the email the day before Ms. Dunn's email was an email involving the 414 at email address. It was addressed to myself, Ms. Mayo, Nicole in my office, was, everybody that had pretty much been on everything that was an official kind of email. And that was me communicating to the court, and I think maybe opposing counsel correctly communicated my position that I could not sign up on an order as the form that we were going to appeal. And at that time, I think it was clear the court did have their proposed order in hand. Right. So I well knew that they had given the court an order. But in practice here, it is not uncommon in the 414 to not have an order signed for a period of time because Judge Bernard spends time contemplating things. Nothing wrong with that. And that's why we waited. And I think at the end of the day, I don't like, look, at the end of the day, I wish I'd read an email. That's all this is about, Mr. Dumas. The email the next day that came back about it being signed was not, would this have made a difference? It was not back to everybody that was sent the email the day before.
It wasn't on the same thread that the previous
Well,
day.
it was actually from Carla at, the
McLean County.
yeah, and I think the record is and that you have that email. So that record the next day doesn't copy anybody. It comes from Carla at whatever. But I should have read it. I mean, I'm not sitting here. I wish I'd have seen it. There's no reason, for me to dodge reading it. And I own up, in 30 years, I haven't had anything like this happen. But thankfully, there is a statute that requires actual knowledge. And that is a benefit to my client. And at the end of the day, the substantive appeal is a substantive appeal. Why Judge Bernard did not find, Judge Bernard had within her power to say, you got actual knowledge on that day, right?
She only have 30 seconds.
Yeah, you got it.
One thing just kind of been troubling me, it doesn't have anything to do with that, probably. But there's so many motions for summary judgment hanging around out there. We do have a final judgment somewhere, right?
No, sir.
That was the question.
No, the summary judgment in question would have disposed of all issues, and it may have even had Mother Hubbard at the bottom of it, and it would be in the record. There were two parties. One summary judgment had been granted, and this was the other party, and the granting of that was going to dispose of everything. That order is gone. The original order, no one has been able to locate it.
I
It's
just had a
not
question
filed.
about, do we have a final
But
judgment?
there's not, I don't know.
For jurisdictional purposes.
I'll let Ms. Maida answer that.
Okay, well, I think I've run everybody over time, so.
No,
I'm happy.
we're here to get some answers, so that's what we're.
Well, that's why she's more than adequate to address these issues. but
We'll address that in rebuttal.
Thank you.
Thank you,
Sorry
Ken.
about that. Thank you.
Oh, Are you gonna be doing all the argument for
I'm gonna cede sometime to Mr. Schuster.
you? You know he's gonna get, you're gonna get less than you asked for, because he's gonna keep talking and answering questions.
I'm gonna do my
and he's
best to, whenever it says talk, to cede to Mr. Schuster. Feel free to throw a pin. in
Y'all
there
got
or
20
something.
minutes.
May it please the court, counsel, Ian Bellavo for Aspen Heights Waco Project Limited. And I wanted to answer some questions that the court had asked Ms. Mehta and Mr. Dunham. First, yes, under Texas Government Code 80, it allows the court to send notices via email. And that is why under Texas Rule of Civil Procedure 57, counsel is required to put an email address that they want any notice from the court to go to. So that's answering two questions. The third one is, I believe, I don't remember if it's Justice Wright or Justice Gray asked it, but the question was asked is, was the trial court allowed to infer when plaintiff's counsel received notice of the emails based on when they received it? The answer is yes. And there are two cases that have come out since the parties submitted briefing on this that demonstrate this exactly. One of them is Rendon v. Swanson, which is out of Justice Wright's former court, the Eastland Court of Appeals. And another one is called Park v. Abudale, which has a Fort Worth Court of Appeals. And in both cases, parties were emailed notices of judgment. They didn't recognize them in their email boxes. And they went and filed 306 motions. And in both instances, the court denied, just like the trial court here did, just denied the motions.
Who were the notices from?
In one of them, Justice Gray, I know that it was from, I believe it was from the court clerk. In the other one, I don't believe it says where the emails came from.
You understand why I asked the question?
Yes,
Because
sir.
there's a difference under 306 as to whether or not the notice comes from the court clerk versus the district clerk.
I think there is, but that's when you get into the actual knowledge part. And this is the part where I think there really is, I'm not trying to parse hairs on it, where I kind of take some umbrage with what's going on here, is whenever Mr. Dunham was up here, he says, well, summary judgment was granted as to one party. That was Mr. Schuster's client domain. Something needs to be real clear here is whenever Judge Menard entered her order on that, what she did is she sent a letter, says, I'm granting domains, summary judgment, traditional motion for summary judgment on the affirmative defensive limitations, filed it with the McLennan County District Clerk's office, emailed it to counsel. There was no order as we normally think of it whenever that was done. And plaintiff's counsel fully recognized the procedural effect of that, because when Aspen Heights filed its summary judgment, they filed a motion for reconsideration of the granting of domain summary judgment. So then on September 11th, Judge Menard did the exact same thing as when Mr. Dunham said, oh, the court had already granted domain summary judgment. Judge Menard did the exact same thing. She signed a letter saying, I am granting.
But you're trying to convert the letter to a letter order, when my recollection of the letter from Judge Menard specifically contemplates further action by the parties to prepare a final order. And this court has specifically addressed that situation as to whether or not that letter becomes a final order or not.
And I think at that point, Your Honor, the preparation of that order, because they didn't say prepare an order on domains. They said prepare an order. At that point, just like in the NRA Yamaha case, the preparation of the order just became ministerial. So whenever Judge Menard filed that letter with the clerk, it in effect became the order granting Aspen Heights summary judgment. And since the prior order, which they acknowledge was a summary judgment.
But that's rendition. The trial court, no question, rendered judgment at that point. But the appellate timetable, which is what we're talking about, is when that final order is signed. And you're trying to infer, or you're trying to draw us back earlier by requiring counsel to anticipate that a judgment's going to be entered. And it seems like they anticipated that because they were already telling y'all that they were going to appeal it because they knew what the judge's ruling was going to be, but it's still all critical about what date the trial judge signed that order.
Okay, well, and I'll tell you, Your Honor, I couldn't tell you how many summary judgments I've had granted over my career. I've been fortunate to have a lot of them. I've never received a separate final judgment, even in multi-party cases. I received, once that order comes down dismissing the last of the claims, that's when I've always considered to be a final judgment. I've had cases where we've had.
So you're arguing that the letter was the final order, even though it contemplated further action of a order that documents what you were told in the letter.
Yes, because just like in the In-Ray Yamaha case where the court sent out a chart saying denied, granted, denied, granted, at that point, the entry of the signing of that order just becomes a ministerial act. But even if the court doesn't go by that, when you read the Rendon case and the Park case, whenever that email with that signed final judgment was sent, and they say it's a personal account, but it was from her official account as the court coordinator. So it wasn't from
But not the clerk of the court.
No, it wasn't.
Okay.
But at that point, when you read the Park case and the Rendon case, at that point, when they received it, they had received it and it's been determined that people have actual knowledge. And I think it's important to go back and really look at what the record said. So what Mr. Dunham testified to at trial is that he goes through, at the end of a week, he looks at all of his unread emails and goes through all of them to see who they're from, to see what's junk and what isn't. He testified that he's had no interactions with Ms. Dunn other than in her capacity as the court coordinator. The email was titled Kim and Terry Scott versus S2S domain et al. With an attachment of final summary judgment as a PDF. Under the law, you're not required to have actual knowledge of what's in the order, only that it has been signed. And that's the In-Ray Rhodes case out of Fort Worth Court of Appeals. You only have to have knowledge, actual knowledge that it has been signed. So at the very least, whenever Mr. Dunham, as he testified, goes through in his emails at the end of the week and reads through them to see what's what, at that point, he would have had actual knowledge. The other point is, this is not, and I'll fully admit that I got it wrong in my briefing too. This is not an abuse of discretion on the 306. It is a legal and factual sufficiency challenge. And as was pointed out, Judge Menard, as the fact finder, was the one who judged the credibility of witnesses and made the determination of what to believe in whole and part. And deference has to be given to her ruling, even if you think there's something else, if there's some evidence. And here there is. Because if you take my argument, if you go back, there's no doubt that Mr. Dunham acknowledged he received the September 11th email. And there's no doubt he acknowledges that he got the November 4th email. He just claims he didn't read it until January 30th. But if you use the September 11th email, if that was the entry of final judgment, because it disposed of all claims against all parties, as I think it's the Harmon case says out of the Supreme Court. I always get that name. But once you have an order that disposes of the remaining claims against any party, it becomes final. And so he had knowledge of that. And so then he couldn't even invoke 306A because he had knowledge of it within 20 days. Remember, 306A is only if you find out more than 20 and less than 90. He acknowledges that he got that email right away. And if you believe his testimony that he went through his emails at the end of the week in November 4th and looked through to see what was what, at that point, he would have had actual knowledge. And if you go by the Park case and the Rendon case, the fact that he received it is enough. That they say that is enough to have received and had knowledge because it's in your email.
Okay, we're arguing a lot about what, and I noticed in your brief, I've noted circled 3 cans with regard to what the trial court could have determined, and 3 times at least you used the phrase could have viewed it a certain way. Where is the harm in abating this on their motion to let the trial court make findings of fact and make a determination of an actual date so that we know what we're dealing with, whether or not she thinks there was constructive notice or actual notice, and she just chooses to disbelieve everybody at the law firm.
So I think that the court could send it back for the limited purpose. And I haven't seen a case addressing this, so I'm going through it in my mind. I apologize if it looks like smoke's coming from my ears, but there are cases where they've sent it back for the explicit purpose of making a Texas Rule of Appellate Procedure 4.2 finding.
That Eastland case did that, right?
The Park case?
Eastland, the Rendon case.
Yeah, sorry, the Rendon. I believe they did. I can't remember. I've read so many of these cases, Justice. I apologize. I believe that in that case they may have, and in that one, the court made that, and I think she initially denied the 306A motion. I'm getting kind of confused, but there is one where it was sent down, but it was before the appeal actually started running. It was at the outset. They said, "Hey, we're going to abate this. Trial court, you make your 4.2 finding." What I don't know is if because here, I don't think with a denial, a court necessarily has to make a 306A finding. I think it can be implied, although as Ms. Mehta pointed out, those cases that was in the Lind case out of the Supreme Court, and other cases have distinguished saying, no, that's a case where they actually granted a motion for a new trial, so it could be inferred. It may not be possible in others. But if you look at the Park case and the Rendon case, I think the problem with that is we've already gone through this whole process. And here, Judge Menard made a ruling, and now the court, I think, has to defer to her because it's a legal and factual sufficiency finding.
But all she had to do was make her 4.2 finding, and that would have certainly clarified and put a point on where the briefing goes.
I'm not here to argue about that. I think if she would have made that finding, it definitely would have been a lot clearer, for sure. But the bottom line is that they're allowed to send these emails out. They send an email out. There's no dispute that it was received. And if you look at the Park case and the Rendon case, I think in deferring to the trial court's denial of the motion, there was evidence there to support the denial.
Well, how do we not run, if we were to say that there's no implied finding here and the rule requires it, how do we not run afoul of Lind? Because Lind says clearly that there can be implied findings, and then they further follow up to the extent that some courts of appeals have held otherwise. We disapprove of those decisions.
Right, and that's what I was explaining earlier. Lind does say there can be implied findings. So here, the implied finding could be November 4th. The implied finding could be September 11th. But then again, as I was explaining to Justice Gray, other courts have distinguished that. Granted, intermediate courts of appeals have distinguished Lind, saying you can only have an implied finding when a motion for new trial is granted. I think the Ned Johnson case is one of the ones that has made that distinction. But again, if you look at Park and if you look at Rendon, I think what the court needs to look at here is the trial court just denied their motion. Was there some evidence to support the trial court's ruling? I think the answer to that is absolutely yes.
And just help me again, what do you think that evidence?
I think the evidence is if you look at the September 11th letter order, there's no doubt Mr. Dunn, that was the first exhibit they entered. And they said it was the order granting my client's summary judgment. They said that on the record. This is the order granting Aspen Heights summary judgment. Yes. So there's no doubt that he got the email. There's no doubt he got notice. And then again, looking at the Park and Rendon case, the fact that these emails, again, there are cases where the emails sat in people's email boxes unnoticed. One of them was actually unopened in an archive folder, and the court said that was notice. I mean,
But
don't get me
when
wrong,
you
this
say,
is
when you say notice, you mean actual knowledge, or do you mean notice? Because notice from the clerk is different than actual knowledge. You don't have to have actual knowledge.
I
if
think
it's
they
noticed.
believe it provided, I don't want to misspeak, but the court said that that was sufficient for not invoking, for a reason enough to deny the motion. Unless you guys have any more questions, I want to
Okay.
cede time to Mr. Schuster.
Thank you. If it pleases the court, my name is Israel Suster, and I'm here arguing on behalf of Domain. I'm just going to talk very quickly about the 306A issue, but there's another issue that we have that the other appellee doesn't have. There's a lack of standing and therefore a lack of jurisdiction. We've argued it in the motion to dismiss. But the court, let me point out to the court that I agree with the way we've briefed it is in accord with this court's ruling in Ray Johnson, that the court is correct that if you have a letter and the court's indicating they're going to sign an order, then that's what's expected. And it would be correct, you would go from the judgment. I'd point out that we have two different law firms got that email. We got the email, they got the email, but the two different law firms and the multiple lawyers on the other side somehow claim they didn't open it. That's not the standard. In fact, the standard is set forth in Ray Johnson, which is a case out of this court. And as I recall, the court did not enter a ruling or a finding as to when notice was received. So you get to the implied finding, and Chief Justice Gray is correct. The question is whether or not they have made evidence or they have proffered any evidence to get around the implied finding that the date of receipt was either November 4th or November 5th, and whether or not they can controvert that. The evidence, I think, is clear that they acknowledge having received the emails. I receive a letter at my office with a judgment and they put it away, or I just put it away and I open it up 2 months later. That's not good enough. That does open up the floodgates, and you have a lot of problems with lawyers arguing the same thing.
Actually, there's a Supreme Court case that says sorry, I don't have the style of it, but if you get a letter, you don't open it, that's not actual knowledge.
Right, but it's receipt of notice. Otherwise, I can put all the orders away and then just.
Depends on who it comes from. If it's from the clerk and you don't open it, you're in trouble. If it's from a third party and you don't open it, you didn't open it. You don't have actual knowledge.
Sure. Justice, real quick, so that I can, my time is very short. Our property under the record is up here. The appellant's property is down here. What they're complaining in the record is actually water, excessive water coming through the city of Waco sewer system. There's no standing to bring a claim against us. There's nothing is happening on his property. He's testified under oath. The box culvert is the city's. There's evidence in the record that when we bought this property, it was all approved, any drainage and the way the drainage happened. So we've got.
So are you telling me that this is sewer water that's standing on their property?
What I'm saying is.
Because this sounds a whole lot like another case I've read recently.
It's runoff. What they're complaining about is water. We're not contiguous. There's a street that divides our property. There's more than 10 acres between our property. Somebody I think else owns the property. We're up here, they're down there. As compared with the co-defendant, they're complaining about another issue against them. But the water, they're complaining about too much water coming down on a drainage ditch through the box culverts, all of it which is owned by the city of Waco. There's nothing that this court or the trial court can do to to remedy the situation. They'd have to go and sue the city of Waco. You're dealing with city regulations. To our knowledge, no one's addressed we're in violation of any city regulations.
Is this standing argument, was it made at the trial court?
Actually, we did complain about it, but standing, and we cited this.
Yeah, I know.
I can complain about it right now. The court always has to determine whether it has standing. So what I'm saying is that there's nothing this court or the trial court can do that would remedy the situation with what's going off, what's happening, or water somehow running off from the city's sewer system or the drainage ditch they're complaining about. And that's.
But isn't that a factual question of where the volume of water that is going into Waco is coming from and why it's going to them and not somewhere else?
Well, not really, because the question is, what can I do to control, or what can my client do to control the drainage system that's owned by the city of Waco? We can't do anything about that. We're not even next to their property. Has nothing to do with that. And then remember, this is a nuisance claim, and it's essentially the stormwater runoff, which is controlled by the city, not my client. And in fact, we have summary judgment evidence I've cited to the record, I think in either my motion to dismiss or the reply, where we point out specifically where we testify, they're complaining about waters running down that are issues with the city of Waco, nothing which we can do and have any control about. So separately from this 306A issue, there's no standing as to our clients, one way or the other. So the court should dismiss. If for some reason it thinks that there's a timely appeal, the court then has to look at that issue of the standing and get past that. And that's in the record, and they can't meet that standard. If you send us back, we're back again on the issue of there's no standing.
I think we have to address jurisdiction no matter when it's raised. So
Correct, Your Honor.
it's.
So if the court has, I see my time is running out, and I think
No,
I've pretty
it's
much.
over. That number's
Okay.
going up.
Yeah, assuming the
That's how
court has
many,
no,
that's how many minutes you're overtime. So it's.
sorry, Your Honor.
No problem.
I assume there's no further questions.
No, we're good. Thank you.
Thank you.
I wanted to first address the motion to dismiss, because what Mr. Suster did not point out is that his motion was the subject of a motion for summary judgment. It was a motion that was denied by the court. The trial court's order again is specific as to limitations. Mr. Suster was empowered to file a cross appeal because there was a dispute as to summary judgment evidence. Mr. Suster is doing what he did in trial court, and I understand advocating for clients. I completely understand that, but you can't say that there is no fact issue by ignoring evidence that's proper from the other side. We presented an evidence from Bob Wallace, who is a respected engineer, and we are actually the only party in this case that hired an engineer and had his affidavit as summary judgment evidence. And that was before the court. And this, Your Honor, you're correct, absolutely correct, Justice Gray, that there is a fact issue. This is not something that the court can resolve. What's more is we briefed this in the summary judgment proceedings, but Section 11.086, courts have said that this is actually a strict liability statute. It goes against the property owner. There is no question that Mr. Suster's client owns the property. He has not come to this court and said, well, I don't own the property. Instead, what he's done is he's ignored parts of the summary judgment evidence, completely ignored the testimony of an engineering expert, and tried to cherry pick between testimony of our client, who said repeatedly, and we cited this multiple times, he said, I'm not an engineer, I'm not an engineer. So Mr. Suster is attempting to manufacture a jurisdictional challenge where none exists. Now, with respect to the remainder, the 306 issue, I was provided copies of the Park and Rendon case by counsel just now, and I wanted to say it's clear. Rendon, if you look at Park on page 5, it says the clerk's record indicates notice of judgment was electronically served. So this is an A3 case. This is a case where the notice came from the district clerk. Now, the Rendon case also talks about it. So in Rendon, there was 18 months where there was no activity in the case whatsoever, and then a dismissal was sent. It says the clerk emailed notice of dismissal along with a copy of the order. So again, the formal notices come from the district clerk. And so these are two cases that essentially talk about what happens when you're under A3. I would submit to the court that we have provided authority, even the Tran case, for example, that underscore actual knowledge means actual knowledge. And in the Tran case, a green card was signed, but there was affidavit testimony set forth saying that this was not received by me. And it was incumbent on the other side to come forth with evidence, whether that be testimony from the clerk, whatever evidence that is, and they chose not to do that. That's the case that we have here.
What about his argument that the email was in Counsel Dunham's mailbox? The testimony was that he reviewed his email each week and went through it. How do you respond that that's not evidence?
I would say, Your Honor, to be quite frank, I am troubled by that testimony because it is a misrepresentation of what was testified to. Mr. Dunham was questioned, so was this unread when you marked it? And he said, there are times I look at my phone and I will mark all as unread. He did not say, I saw this email and I marked it as unread. That's not the testimony. That's the testimony. The testimony is, he said there are times where he used the mark all as unread feature because for whatever reason. So that's the testimony, is not that he saw this email and he's like, okay, Mark, he's not talking about going through emails one by one. This is a situation where there is no evidence on the other side. They can try to cast aspersions at Mr. Dunham, which they've done, but this is not, you can't have a credibility determination when there is no evidence controverting on the other side. And I believe that this court was clear and clearly understands counsel's position that rendition cannot be in order, that there is a difference. So I will not wade into that. We did brief that. I do see my time is running. And I do want to say that if you flip to page 1 of the rules of civil procedure, this first rule talks about the rules should be construed in a liberal manner where possible to do justice. We're not even asking for that. We're asking for the rules to be construed in a literal manner as they are written, which is always the requirement of any statute or any rule. And in this case, the other side is arguing it should not be, and the damage is our clients are deprived of their day in court. They're not asking this court to say they win on the merits. They're just asking for the opportunity to stand in front of the jury of their peers and say, this is what happened to me. I was wrong. Do I get redress? And if the court has no other questions for me.
You're good. All right. Thank you, counsel.
Thank you.
I will make the point that if your name ends in an X, it's Rendon. If it doesn't end in an X, it's Rendon. So the case out of Eastland, because I noticed both of y'all were calling it Rendon, you were calling it Rendon, and so that is the same case, right?
Yeah.
Okay. All right, y'all have a good day. This case is submitted. Y'all are excused.
Thank you, Your Honors.